Thank you for your invitation. It is a great honor for me to be here with you at the CEIPI and have the chance to present to you my ideas on Lean IP. My name is Oliver Baldus. I studied physics as well as economics. I am a German and European patent attorney and partner at Splainman, which is the oldest patent law firm in Germany. Most of you might already have heard about the economic concepts of lean management and lean production, and I want to give you a brief introduction and some insights into the beginnings of these concepts. We will get later back to this. Yielding efficiency in production is definitely not new and can be traced back to the origins of human civilization. Doing work efficiently is deeply anchored in human nature. Even in ancient Rome, people strived to do work and build processes as efficiently as possible. Of course, there were always people who were more skilled in this task than others. One of these skilled men was Henry Ford, who invented industrial production and revolutionized the corresponding workflows in assembly lines. I remember when we recently discussed the concept of lean IP, this man immediately came to our mind. In this context, Alex mentioned that Henry Ford in the 20s of the last century not only invented the assembly line, but also adapted the product itself, namely the car, to mass production. For Henry Ford, an efficient industry was the sole key to prosperity. This demonstrates that he not only had in mind his own firm, but also considered larger social national contexts. Another quote attributed to him is that resenting efficiency seems to be a mark of inefficiency. This shows that not only we in our time, but also Henry Ford already faced some kind of resistance in restructuring production. However, Henry Ford's relentless pursuit of efficiency through innovative production techniques, standardized parts, and a focus on economic well-being transformed the automotive industry and left a legacy on modern industrial practices. However, despite Ford's contribution, many efficient measures in production were out of focus and yet uncovered. For example, the automotive industry in the U.S. still relied on buffer production in 1980. Automotive manufacturers operated assembly lines continuously and permanently under full workload to constantly replenish all warehouses with their goods to be in stock. However, buffer capacity and storage problems often led to an adverse effect on the overall performance. Misaligned buffers lowered efficiency, reduced flexibility, and increased the complexity of production systems. This was the situation when in year 1988 this man appeared on stage. His name is John Krafcik, and today he is the CEO of Waymo. Waymo produces self-driving cars in Silicon Valley. He defined production efficiency as the absence of waste and firstly used the term lean production for it, with waste defining as anything that does not add value that the customers are willing to pay for. His studies became the basis of Womack's book, The Machine That Changed the World, a study on lean production. Reframing efficiency and creation of the positive term, lean, was a necessary step forward to convey his ideas to a broader audience and to promote his ideas. In the following years, lean production conquered, in fact, the world, and the title of the book, The Machine That Changed the World, literally became true. In addition, many other branches of the lean concept appeared, like, for example, Lean Startup, a methodology for developing products and businesses, particularly startups, which emphasizes rapid iteration, customer feedback, and validated learning to minimize the risk of failure. Lean Procurement, an approach that focuses on maximizing value by improving efficiency and reducing waste within procurement processes. Lean Marketing, a data-driven approach to marketing strategies focusing on iteration, testing, and measuring results. Lean marketing helps optimize the marketing process to avoid costly and unnecessary mistakes. Lean HR, an approach that is focused on employee relations. This is a critical issue for organizations undertaking lean transformation to create a lean culture of continuous improvement, since it was recognized that people are the biggest factor necessary to ensure success. This was very common to be overlooked. Lean Six Sigma, an approach that uses a collaborative team effort to improve performance by systematically removing operational waste and reducing process variation. It combines many tools and techniques that form the toolbox of lean management and Six Sigma to increase velocity of value creation in business processes. All this demonstrates that lean is not only a term or a buzzword. It is a management philosophy in which the key is the maximum use of currently available resources and the elimination of all waste. Perhaps you already have an idea what is missing here in the lean family. Lean IP. But before we get to lean IP, it is necessary to analyze where we start from in the conventional IP word. Only if we know and are aware of the original background of conventional patent management can we undertake the necessary improvements that finally also lead to more efficiency in intellectual property. Improvements that I call lean IP. Patent management is dominated by two key principles, namely the bottom-up approach and the internal view of the firm. What does this mean? Bottom-up. Imagine the patenting process in a firm. Firms regularly comprise research facilities in which people work to make inventions. These people, by virtue of their work, make inventions and report these to the corresponding IP department. Then many of reported inventions are filed by the IP department and prosecuted up to granting. Might that be by external or internal patent attorneys? Then again, some of these patents are economically successful, but many are not. Top-level management is not involved in all these kinds of processes and does not take any notice about IP until the cases get relevant or problematic for any business operation. This means IP comes from the bottom and literally bubbles up to the top of the company. Internal view. The internal view is governed by the idea that we must protect our ideas against other companies in the business environment. Since our inventions are so brilliant, these ideas would be automatically copied if not protected. However, surprisingly many firms hold numerous self-generated patents for which they would never be willing to pay if purchased from another entity. These are held only due to a too internal and self-focused view of the own company. In psychology, this is called the endowment effect. We invested so much in this idea, and consequently this idea needs to be protected no matter what the financial return of this IP protection will be. According to Forbes, more than $5 trillion has been spent in the U.S. alone on research and development over the past 20 years, much of which went to create the very patents that remain unlicensed. According to Forrester Research, U.S. firms annually waste $1 trillion in underused intellectual property assets by failing to extract the full value of that property through partnerships. In other words, we are pouring money and productivity down the drain. However, the analysis of Forbes remains questionable. Could the underused intellectual property assets really be commercialized if we only spent more effort to search for infringers? Another Australian study finds. Nonetheless, based on the mail-out survey, we estimate that 28% of inventors who submitted a patent application between 1986 and 2005 and 30% of those who received a patent were aware of copying at some level. We estimate a litigation filing rate of about 0.5% filings per stock of patents in force in any year. In half of the applications where copying was believed to have occurred, at least some steps were taken towards enforcement. But to also express this finding the other way round in a broad manner, at least 70% of patents presumably are not infringed. Another renowned author, Mr. Bartenbach, some of you might know him because he wrote the book on the German Act for Employee Inventions, writes that it is estimated that currently only 15% of all patents have relevance to the market. And it was about 10 years ago when I asked myself why so much money is spent on IP when it obviously has no impact on business and there is no return on investment. Now, give me chance for a small excursion for better understanding the later concept of lean IP. Our economy is organized in supply chains. A supply chain is a complex logistics system that consists of facilities that convert raw materials into finished products and distribute them to end consumers or end customers. Supply chain management deals with the flow of these products in distribution channels within the supply chain in the most efficient manner. And as you can see here, usually every company has a vast number of entities to which it has some kind of relation. These are not only direct competitors, but also suppliers or demanders. Each company is embedded in a complex network of relationships, and IP rights can have effect at every position at the complex network of the supply chain. We will get back later to it. Bottom-up and internal view form uncoordinated approaches that lead to randomly scattered patents within the network of supply chains. IP rights appear and disappear everywhere and randomly in this area. Some people denote this situation as patent thickets, webs of patents, or patent entanglements. This often requires reaching licensing deals for multiple patents or inventing around. A company must hack its way through this jungle to in fact commercialize its modern technology. I personally would consider this as a minefield. A minefield containing large and dangerous or small harmless mines, fake mines, suddenly appearing or disappearing mines. And then, some time ago, I encountered the quotation of the former Prussian General Karl von Clausewitz about the fog of war. War is the realm of uncertainty. 3/4 of the factors on which action in war is based are wrapped in a fog of greater or lesser uncertainty. A sensitive and discriminating judgment is called for a skilled intelligence to scent out the truth. And I thought to myself that this judgment equally describes the situation in the IP world. Thus, I call patent thickets the fog of IP. Can we do better within the fog of IP? Yes, we also need a sensitive and discriminating judgment that is based on two different concepts than before. We firstly need an external view of the firm instead of an internal, and secondly, we need a top-down approach, but not a bottom-up approach. External view of the firm. It is not required to protect products that are interesting to us, but interesting to others, i.e., we should start patenting from a market view perspective. We should protect products that have market relevance, which are interesting for others and not primarily for us, and that can be commercialized on markets. For these products, it is automatically possible to find potential infringers. And within this view, the economic value of a patent corresponds to the value of the protected matter. Imagine a complex molecule that can be used for treatment of a widespread disease, like Alzheimer. This will be a multi-billion-dollar asset. Now imagine the same molecule, but differing in one single chemical bond that cannot be used for this purpose. It has no effect on treatment or is even harmful. It is based on the same technology, same chemistry, same production facility, but despite its similarity to the billion-dollar asset, it is worthless. Kraftsik would call it waste. The external view teaches us that the value of a patent is a direct proxy of the market potential of the protected product. And as the market potential of the product varies over time, the value of a patent varies also. Top-down approach. And to be in the fog of IP perspective, it is inefficient to scatter mines completely randomly over the battlefield. We should use our mines at places where the enemy comes along. Thus, the top management decides where to place these mines to reach its strategic goals with respect to other targets. Consequently, we do not scatter our mines in a dumb approach, but place them with skilled intelligence in view of our targets. The management of the firm decides on strategic goals for the enterprise. Achieving these goals is then leveraged by IP rights. How do we identify patents lacking an infringer based on the external view? We take a closer look at the independent claim, close our eyes, and imagine the corresponding product. We ask ourselves how the market would react to protected products and whether the product could be actually sold on markets. What would the revenue be like? Can it easily be overcome or bypassed by other solutions? Is the product too expensive in comparison to the technical solution achieved by it? Do we need golden anchors for ships that sink to the ground faster than those made from steel? Would a potential buyer pay for this or a corresponding patent? And by doing these considerations, you can easily identify waste. Some quite common examples. Independent claim describes protected matter in a too detailed manner. The claim describes a plurality of 20 technical features. According to the all elements rule, every single element of a patent claim must be present in the accused product or process. However, products characterized by 20 technical features are extremely unlikely to be ever significantly infringed, or the independent claim comprises features that do not contribute to the self-defined technical solution. Thus, the claimed technical solution can be easily bypassed when the non-contributing feature is replaced by another one, or the independent claim describes strange or obsolete matter that cannot be reasonably merchandised or would never be used, like the depicted saluting device. Based on the external view and the aforementioned considerations, we now can do portfolio cleaning, i.e., identify and abandon assets that do not add value to the firm. Due to its nature as a prohibition right, a patent needs an addressee, i.e., infringer. All patents without a possible infringer are worthless assets and actively abandoned. Own patent applications are monitored with respect to their scope of protection. External view, application handling. How does lien IP behave with respect to application and patent handling? Application and patent handling can be divided into 4 phases. Phase 1 is the pre-filing phase in which the lien IP process regularly starts when the invention disclosure reaches the IP department. As you might know, inventors often have weird ideas. And here it firstly checked whether this idea has some sort of market potential. Is it in fact an idea that has the potential to bring money back to the company? If it is, for example, a saluting device, neither drafting nor filing an application is initiated. Instead, the invention is released to the inventor. However, here first psychological problems occur, and many firms simply file everything to avoid any mistake that could happen due to wrong releasing it. This is the first waste factor. Phase 2 is the after-filing phase. This phase is entered when it was realized in Phase 1 that in fact some kind of market potential can be contributed to the invention. The application with claims that are broadly directed to the basic idea is filed with Patent Office. However, in Phase 2 claim restrictions might be necessary that can move the claimed matter away from its market potential. This means that the initially claimed idea based on market potential now shrinks to something smaller that has not necessarily also a market potential. If this is inevitably the case, the application must be actively abandoned to avoid waste. But here strong psychological effects appear. In economy, we call it the problem of sunk cost that refers to the tendency to continue investing in failing endeavor because of the resources already invested, even though it is clear the investment will not be worthwhile. Phase 3 is the after-granting phase that should reach only those applications that protect products that have significant market potential. This market potential is continuously monitored since markets shift over time. 10 or 15 years ago, patents for efficiently producing compact discs could be value-adding since compact discs were articles that could be sold. However, nowadays patents for compact discs are waste. Phase 4 is entered when opposition or nullity proceedings are initiated. These are also often accompanied by a shrinking scope of protection. However, here often fierce and costly battles occur on economically useless subject matters. So, the advice of lien IP is that as soon as you realize that you end up unambiguously in a non-value patent, you will immediately end these proceedings. However, this is the stage where the aforementioned psychological effect of sunk costs becomes predominant. Because we invested so much money in this patent, we want to keep at least something on paper. But this is costly wrong thinking and definitely creates waste that subtracts valuable resources from the firm. After all the cleaning process is done, the next step comes in, namely using the top-down approach to further achieve and leverage your business goals. Here it is necessary that the top management defines specific goals that must be reached with respect to other targets. These targets are other neighboring entities within the supply chain. Then achieving these business goals is leveraged by IP rights. Examples of these strategic goals with specific targets could be: our firm wants to gain market shares from our direct competitor. Here the target is the direct competitor. Or, we want to lower procurement prices from our largest supplier. Here the supplier is the target. Or, we want to yield higher prices for our products purchased from a particular demander. Here the target is the corresponding demander. However, these are only a few examples out of a set of million other goals that could be leveraged and enabled by IP rights. I will demonstrate this to you by way of the discussed cleaned portfolio example. After IP portfolio cleanup, you might end up in a situation when top management decides, we want to gain market shares from our direct gear competitor. And now I ask you, should we, as the red company, really exert our IP rights against the green company? What could happen? In fact, it is not wise to do so. If we treat our competitor aggressively, it is extremely likely that he will hit back on us and retaliate. In this situation, we in fact own IP assets that are in principle also value-adding. But unfortunately, we cannot use our rights since we are in an inferior position with respect to our target. That is the situation, for example, when the Danish army stands against the US Army. The Danish army can in principle definitely create some kind of absolute impact. Nevertheless, no one in his right mind would send the Danish army against the US Army. The Danish army could be effectively used against Vatican City, but not against the US Army. The same is true in this IP situation. Although our IP activities cause some kind of absolute impact, they cannot be used with respect to this target. In our relative position to the target envisaged, our IP rights do not add value and remain inefficient waste. To more clearly analyze this IP situation, my colleague and I developed the 4W matrix. The 4W matrix shows the relative IP strength, RS, that is given by your IP strength divided by the IP strength of the target. It has 4 different segments. In the wasteland segment, the relative IP strength is not clearly defined, since an IP potential for hitting the target and the target's IP potential for hitting the firm is indeterminate, like for example for retailers. This situation often occurs in non-technical business segments in which IP rights are not provided. However, this situation also frequently arises between suppliers and purchasers that operate in different technological areas. The one cannot hit the other and vice versa. In the weaknesses segment, the hitting potential of the gear producer is much weaker than the potential of his target. This situation can arise, for instance, in startups or new firms entering the market. These companies regularly possess only small patent portfolios and are confronted with large and dominating competitors. In the wall segment, the hitting potential of the firm and the target are more or less equal. In practice, this is a very common situation between competing companies. The situation in the wall segment is very stable. Game theory shows that as long as companies reside in the walls segment, mutual tolerance and cooperation is the most efficient strategy. Here IP rights serve as walls that protect the firm, but do not allow an active attack. Finally, the weapons segment foresees the hitting potential of the firm being much greater than the target's potential for hitting the firm. Consequently, the firm does not have to fear a counterattack by the target when deciding to enforce its IP rights in order to exert pressure on the target. It is this weapons situation in particular that patents can function as catalysts for a firm's business strategy by acting as a leverage point against the target. The interesting thing in this view is that the value of IP rights is to be determined with respect to the specific target, since enforceable IP rights are more valuable than those that are not. And that is the reason a patent in the hands of a patent troll can be a devastating weapon. It is not possible to hit a patent troll since it is a non-practicing entity. It is an army you cannot hit. The IP ratio between you and a troll is always determined by dividing by 0. This means a troll can always exert IP rights without having any fear of counter-retaliation. In contrast, one and the same patent not in the hands of an immune troll, but in the hands of a weak startup company could not be enforceable. Imagine a small startup against Google. Patents do not have an absolute value, but only a relative value with respect to a particular target due to their relative enforceability. Consequently, to implement our self-defined business goals, it is required to gain IP supremacy. What could we do to this end? Strengthen our own position. We, on our own, could file patents that effectively block our competitor. However, to this end we must place mines in front of him. But to be efficient in that means we have not to improve our own technology, but to enhance technology of our competitor. We must analyze his products and make inventions for his technology that he does not foresee. For having Apple as an infringer, it is required to make invention that relate to the iPhone. That is another example where the external view comes in. Another approach is, for example, trying to buy patents in this area. Also, an efficient but dirty measure is to file non-examined utility models. Design rights. Trademarks could play a role as well. But that is only one side of the medal. The other is weaken our target, so that the ratio further turns on our side. We could initiate opposition or nullity proceedings, or try to buy some of his patents by a straw man company. And when we manage to coordinate our IP activities in a sneak attack against the target, we will end up in a situation where we can tell our target what to do and what to do not. And all this relies on the Prussian general insight of a sensitive and discriminating judgment, a skilled intelligence to scent out the truth to lift the fog of IP. And now some words about patent quality in lean IP. Recently, there was huge discussion on patent quality and the patents issued by the European Patent Office, until it was realized by the participants that obviously everyone understood patent quality as something different. So, I want to share some thoughts on patent quality in the context of lean IP. It is important to understand that when talking about quality, it is not sufficient to only say that something is of a bad quality. It is always required to measure quality with respect to a certain reference and to rely on a particular judgment background. For example, a car can have bad quality with respect to its technical features since the steering wheel breaks easily or door handles corrode, but in contrast, a car can also have bad handling quality. Same holds true for patents. Patent quality must be measured with respect to a particular reference or frame, and it is not sufficient to simply state that a patent has a good or bad quality. And there are 3 references that play a role with respect to the quality of patents. 1. Legal quality. The legal quality of a patent is given by compliance with all legal requirements of the underlying legal framework. Patent law is the society-defined framework in which every patent is embedded. Non-complying to these legal standards can have consequences starting from minor flaws causing rectification costs up to extremely severe defects, leading to revocation of the whole patent application. The most important issue of any legal quality is that the self-set claims distinctly define the matter for which protection is sought. Verbose descriptions are also suboptimal since they contradict the principle of self-interpretation of the claim. In general, short and lean descriptions can completely comply with all legal quality principles and provide many advantages, like low translation costs. 2. Substantial quality. Substantial quality means that it is not possible to invalidate the patent based on prior art. Patents can be invalidated if prior art is found. That leads to the assessment that the claimed subject matter was not new or based on an inventive step when filing the patent. Patents with high substantial quality withstand corresponding legal attacks, and their invalidation is unlikely. In this case, another quality objective is given by prior art. However, the difference to the former objective is that although prior art is also predetermined, it is a priori unknown and must be costly searched. Since every prior art search is imperfect by nature, it can never be guaranteed that all relevant prior art documents for assessing substantial quality are found, even if comprehensive searches are carried out. Since a patent is never valid beyond all doubt, substantial quality is a likelihood measure that can never reach 100%. 3. Economic quality. Last but most importantly, granted patents should have economic quality. Economic quality means that it is possible to create revenues with the protected invention. Here the reference is the market. The economic quality of a patent is again independent from legal or substantial quality, i.e., a patent can have legal and substantial quality but lack economic quality. And here it is important that the claimed subject matter can be commercialized. Regularly, not the market adapts to the claimed subject matter, but the claimed subject matter must adapt to the market. Also, here you again encounter external perspective. Patents that contribute to IP superiority should have all three characteristics, since otherwise they cannot be seen as value-adding patents. And I was interested to find out whether lean IP is already in use by companies. So, in a reality check, I investigated current IP strategies of large companies like Siemens. It turned out that these companies use a sophisticated approach that is characterized by their extensive diversification across a multitude of business areas. In each branch of the company, a unique IP strategy is used that follows the lean IP ideas. Across all divisions, a strategic and value-oriented IP management is implemented that is strictly focused on whether IP rights in fact add value to the company. Small firms can profit as well from lean IP, which can be more easily implemented in small or mid-sized firms. Small firms can be far more easily restructured than larger ones to adapt to lean IP principles. It was a long journey on our talk today, and I hope that you are still awake. To my opinion, lean IP is the #1 future tool for lowering costs and increasing profits from your IP investments. It is the first choice tool if you want to get back most return on your IP investments and avoid costly waste. And if you can decide whether to implement lean IP, take the advice from the inventor of lean management, John Krafcik. If you come to a fork in the road, take it. Thank you for your attention.